Hi guys, welcome back to The Brief. I'm Sanam Siddiqui.
I'm Dheeraj Gupta. Today, what do we brief you on?
The brief last week.
This judgment of GAMMON India Limited versus the NHAI, filed under Section 34 of the Arbitration and Conciliation Act, challenging an award, was passed way back in 2005-6. It lays down the urgent need for the NHAI to take a policy decision on the manner in which disputes with contractors need to be resolved.
The learned judge stated that multiplicity of arbitral tribunals is a waste of resources. In fact, in this case, there were 3 arbitration claims that were filed before 3 different arbitral tribunals at different times. And even after 20 years from the date of the agreement, the parties were still battling it out in court.
The Arbitral Tribunal declined the claim of the petitioner by a majority ratio. And what is to be noted is this was claim number 2 out of the 3 claims that were filed.
Petitioner submitted a rather curious submission stating that the findings in award number 3 should be relied upon for setting aside award number 2.
What was the question for consideration for the court? Whether it is permissible for the contractor to jettison the findings in award number 3 to argue that award number 2 ought to be set aside. None of the subsections of Section 34 lay down a provision wherein subsequent award can be used to argue that a previous award can be set aside on that ground. There are only limited clauses that allow you to challenge an award under Section 34 of the Arbitration and Conciliation Act.
The Honorable Court dismissed the challenge to the arbitral award and stated that in respect of a particular contract or a series of contracts that bind the parties in a legal relationship, endeavor always ought to be to make one reference to one arbitral tribunal. The court also stated that if under a contract disputes have arisen and arbitration clauses to be invoked at different stages, then the party invoking the arbitration ought to raise all claims that have already arisen on the date of invocation for reference to arbitration.
If arbitral tribunal is constituted for adjudicating some disputes under a particular contract or a series thereof, any further disputes which arise in respect of the same contract or the same series of contracts ought to be ordinarily referred to the same arbitral tribunal. In cases belonging to this category involving different parties at the same organization where common or overlapping issues arise, an endeavor could be made to constitute the same in arbitral tribunal.
At the time of filing of petitions under Section 11 or Section 34 or any other provision of the Arbitration and Conciliation Act 1996, specific disclosure ought to be made by the parties as to the number of arbitration references, arbitral tribunals, or court proceedings pending or adjudicated in respect of the same contract, and if so, the stage of the said proceedings.
If there are multiple challenges pending in respect of awards arising out of the same contract, the parties ought to bring the same to the notice of the court adjudicating a particular challenge, so that all the challenges can be adjudicated comprehensively at one go.
Why is this judgment important? Because it discusses the law on multiple arbitration in respect of a single contract. It also sets out a new practice and filing directions for petitions under Section 34 of the Arbitration and Conciliation Act.
Well, thank you for watching.
Oh